Good morning, everyone. It's me, your host, Abhishek Singh. It's my privilege to have our special guest, Shree Kapil Sibal, sir. And now I would like to call Dr. Vijay Lakshmi Sharma, School of Law, Manipal University, for a welcome note to sir.
Yeah. Thank you so much, Abhishek. Thank you, everyone, for being here with us today. It's a matter of great honor for me to welcome Honorable Mr. Kapil Sibal, a legal luminary, member of Rajya Sabha, senior advocate of Honorable Supreme Court of India. I welcome you, sir, on behalf of the School of Law, Manipal University, Jaipur. Sir has served in the portfolio of HRD Ministry as a Minister of Law and Justice and Minister of Communication and IT previously, and has served as Additional Solicitor General of India. With a vast amount of experience in the field of law and advocacy, it would be a great pleasure to interact with you, sir, and listen to your ideas and thoughts about the topic of discussions for today. We hope that your knowledge and experience will inspire and motivate our law students and even we all faculty members as well to never stop learning and being committed to this noble profession. I once again welcome you, sir, and also express my deep sense of gratitude for sparing your precious and valuable time with Manipal students. I invite our guest, Honorable Kapil Sibal, sir, for sharing his words of wisdom with Manipal law students. Welcome you, sir.
Thank you. Thank you very much. First of all, I'm absolutely delighted to be with you today. And you talked about my precious, valuable time and sparing moments to speak to you. In fact, time is always precious, but nowadays moments are free for the simple reason that we are in the midst of a lockdown. So I have ample time with me. It's always a delight to be with students, and perhaps you might not know, but I started my career as a teacher. I used to teach history in Delhi University. And I taught history for 3 years. I taught modern constitutions. I taught a bit of medieval history and modern Indian history. So I just love students and love being with students. It's unfortunate that I sort of left academics and took to the profession. But that was, of course, the choice that I exercised. Now, coming to the topic, which is the art of advocacy, somebody may, ask me, what's the recipe for success? To be a successful practitioner? And the answer to that is, I don't know. It's difficult to set out factors that will lead to people's success because the factors are so enormous and so different. It all depends on an individual's personality. Remember, ultimately, the art of advocacy involves persuasion. So it involves powers of persuasion. Persuasion requires logic. Persuasion also requires emotion. Persuasion also requires intuition. And you don't know what factors really work for the success of a lawyer. Many a time it is your temperament. It is your ability to be friendly with people. It's also how you carry yourself, what your demeanor is. It's how you conduct yourself in court, how you conduct yourself with the judge, how you conduct yourself with the opposition. It depends on how hard you work, what kind of time you put in to master your brief. It also depends on your intuition as to what kind of questions may be asked by the judge or what kind of questions may be raised by the other side. So I think it's just like, one doesn't know what it takes to make a tasty dish at home. There may be several ways to make the same dish and it's equally tasty. So what dish should be made at what time or not and by whom, it all depends on, on the mother. So To that question, my answer is I don't know. I think all of you have individual personalities. All of you have characteristics which you best know. All of you have a particular kind of temperament. I think what you need to do is to understand what is required in the law when you are practicing law. And therefore, let me now explain to you what is the fundamental premise on which we practice law in order to become a persuasive lawyer. Okay? So, what is law? Has anybody ever thought of that question? What does law do? Law ultimately sets out parameters for relationships of individuals, of institutions, the relationship between individuals and state, between communities and state, the relationship in dealing with each other in terms of commerce. So all aspects of societal interrelationship is what law is, because it regulates those aspects, all those aspects. It regulates relationship between husband and wife. It regulates relationship between children and parents. It regulates relationship between individual and state, between two trading partners, between those who want to invest in stocks. It regulates that through SEBI. So every aspect of human activity is attempted to be regulated for peace and security. That's what law is. Now, if you understand that, then you will ask yourself the question, then how do I move forward? And I will tell you that as a student, you must try and gain knowledge of every aspect of law. In other words, every aspect of human relationships, every aspect of relationship between man and state, between husband and wife, between in commercial matters, between a buyer and a seller, between an investor in equity in the equity market, between the regulator of the equity market and the investor. So you must have knowledge of economics. You must have knowledge of literature, because many a time literature is a great asset in a court of law, because you can quote people to make your point. You have to be knowledgeable about trading matters. You have to be knowledgeable about philosophy, about the great thinkers like John Locke, Hobbes, Rousseau, Marx. Why do I say that? Because in a court of law, you never know what issue will arise. You never know what is going to persuade the judge. And a little bit of knowledge of any of these things helps you to understand the art of persuasion, because of the vast breadth of your knowledge. So I would advise each one of you, and I don't know whether you do it or not, because we are in the internet world. Nobody reads newspapers anymore. Yes, and we also want to, not waste time by reading sentences. And so we go through news as if we are, going through something that we wish to finish in about 5 minutes. But I think you need to think about that. I think you need to invest time in all aspects of human life, in all aspects of societal relationship, because they relate to economics, philosophy, literature, and many other things, including history. Hello?
Yes, sir. Yes, sir. You are.
Including history. So the fundamental premise on the basis of which you can hope to be a persuasive lawyer is to be knowledgeable. And knowledge means not superficial knowledge, which is why they say that law is a very jealous mistress.
Yes, sir.
Because you will find very few evenings that you have to yourself. Most of these evenings are spent poring over books, trying to understand complex issues. So that's the first quality of a good lawyer. I've had the great privilege of being with perhaps the greatest lawyers this country has produced. From Palkewala, from Daftari, Palkewala. I've watched Setalwad in court. And of course, my contemporary friends, of course, who were about 15, 20 years senior to me were Jethmalani, were Fali Nariman, Soli Sorabji, Ashok Desai, who just recently passed away. These are contemporary stalwarts. But I've had linkages right from Daftari's days. So I know what kind of lawyer is a success in court. And I can tell you this, all of them were highly knowledgeable people. People who knew about industry, who knew about mechanics, who knew about science, who knew about technology, who knew about history. So that's the first quality of a good lawyer. The second, and something that you must understand, and it's very important for you to appreciate, is that this is one profession where Article 14 applies. This is a profession where those who stand up in court have equality of opportunity. In no other profession will you have equality of opportunity. Not between doctor and patient, not between chartered accountant and a company, not between, nowadays in the social setup that we live in, between husband and wife. Those relationships are all unequal, unfortunately. But this is one profession where equality and of opportunity is seen in court. Why do I say that? Because both you and the opposite counsel has the same brief. The pleadings that are available with you are available with the opposite counsel. They're also available with the judge. So all three of you stand on the same footing because you have the same raw material. It's what you do with that raw material. So therefore, as a lawyer, you must go into court believing that there can be no discrimination against me in terms of equality of opportunity. I will have the same opportunity as the other side. And the judge will ask me the same questions, depending on how I put across my case. Number three is that the only way to win a case is to be better prepared than anybody else. In other words, you need to know your brief better than your opponent. You need to know your brief better than your judge. That is the only way that you can persuade the judge and you can get ahead. So in order to be better prepared than the opponent and better prepared than the judge, the third quality you need is industry. You can't be better prepared than the judge and better prepared than the opponent unless you've worked hard. So 99% of success in the profession of law, like perhaps in many other professions, is industry. You have to sweat it out. You have to work day in and day out. I remember when as a young lawyer, it was very difficult for me to sleep because I constantly thought about the case in my mind. I constantly thought about what the judge might ask. I constantly thought about, on this brief, what the other side may argue. Do I have answers for that? If I don't have answers, what am I going to do? And I couldn't sleep at night. So without perspiration, there can be no success. And 99% of all that is perspiration, of success is perspiration. So industry is at the heart of it. The fourth quality that you must possess, and that's very important, is to be pleasant in court. Remember, when you're having a dialogue with anybody, you cannot win an argument by getting angry. You can never win an argument by getting angry. In fact, when you get angry, the relationship between whoever you are angry with deteriorates. So, therefore, never get angry in court. You may be confronted with the most foolish question and the most foolish argument. Don't make them feel foolish. So never get angry. The fifth quality that you must have is that you must always respect the judge as well as your opponent. Respect the judge for what doubts he may have. His doubts may be unfounded. His understanding of the law and of the statute may be completely unfounded. You never make him feel that he doesn't know. You must make him feel that he knows more than you. That's the only way to be able to persuade the judge. But of course, in order to persuade the judge, you must also be armed with very strong arguments, which will go back to the issue that I raised earlier, namely the kind of work, hard work that you put into your brief. So that's the fifth quality that you must have. The sixth quality, which I think is absolutely essential, is that you must never be afraid. In fact, Lord Denning was once asked, what's the greatest quality of a successful lawyer? And he said, courage. In fact, if you ask me in life, what matters most is courage. Courage not foolishly exercised, but courage with conviction. Courage consistent with what your conscience tells you. The exercise of courage, knowing that what you are saying and what you are doing is right. Courage comes by following the path of righteousness. In other words, you can stand up and tell the court, have the courage to tell the court, if you are convinced that the court is wrong, politely, not with anger. That's very important. That's the sixth quality. Now, let me tell you about something let me tell you about a story that perhaps you don't know. This is a story of a young man, that is me, at the young age of 24, 25, appearing in the Supreme Court before a bench which was presided over by a judge from Maharashtra, Supreme Court judge from Maharashtra. And the two other judges were Justice Bhagwati and Justice Sarkaria. And the client came to me, and I was a young man, I was a briefless lawyer. I used to, and that's the quality I'll come to a little later, I used to go to court, from court to understand things. But anyway, so a young man came to me, and it was an election matter. And he had, his election had been set aside by the High Court in Punjab and Haryana. And he had heard me in some miscellaneous application, and he came to my office one day and he said, sir, I have an election appeal that's coming up, and all the records are ready, and I would like you to do that matter. And I was, of course, delighted because I was a briefless lawyer. And I said, fine, I'd love to do it. And he said, but sir, there's one problem. And I said, what? He said, sir, I don't have any money. I said, what does it matter if you don't have money? I was delighted that I got an opportunity. So the sixth or the seventh quality is seize the opportunity you get. Never think about money. It's those opportunities that will make you or break you. If you start talking about money, you may lose the opportunity. And as a young lawyer, opportunities are far more important than the consideration you get for the services that you render. So let me go ahead with the story. So the brief was about 2,000, 3,000 pages, and the young man his election had been set aside. He was also about 24, 25. He was perhaps the youngest man in the Haryana Assembly. The assembly, I still remember, was Mehem, from which he had won at that point in time. And the presiding judge in the Supreme Court was Justice Palekar, who was a judge from Maharashtra. So, as you know, that under the election law, under 116A, there is a right of appeal. So since I was a briefless lawyer, I sort of pored over the brief day in and day out and got ready with it, and I knew it backwards. And when I went to court, and the matter reached in about a month or month and a half's time, and when I got up in court, Justice Palekar, I said to the judge, I said, look, there is a right of appeal, and so therefore you have to admit this appeal. And Justice Palekar said to me, young man, you don't know the custom of this court.
Yes, sir.
You don't know the custom of this court. We don't just admit appeals like that. You have to convince us why we should admit your appeal. I said, but there's 116A. He said, maybe there, but that's the practice of the court. So I said, fine. So I said, don't look at your brief. And I sort of spoke for about 30 to 40 minutes without referring to the brief at all. Told them about the case, about the issues in the case, the legal issues, the factual issues. And at the end of 40 minutes, Justice Palekar said, yes, young man, we'll admit your appeal and we'll hear it right away. So that tells you that unless you work hard, unless you know your brief, you won't get ahead. All right. So when I started arguing the case, one of the points involved in the case was that this young man, it was found, had between the date of his nomination paper and the date of withdrawal offered money to another candidate who had filed his nomination to withdraw from the election. And that fact was proved that he offered money. So when I got up to argue, the Justice Bhagwati said to me, he said, young man, I have just rendered a judgment 2 months ago. This was immediately after the summer vacation. He said, just before the summer vacation, I have rendered a judgment that anybody who gives money in this fashion commits a corrupt practice. And since these facts, I'm sorry, I don't know what's happening. And since these facts have been found, I don't think we should hear the case any longer, but it's covered by my judgment. Now, I knew that it was covered by the judgment. My case was covered by the judgment. But I had, studied the law, went into the law, and I found that the judgment was perhaps not right. So I had the courage to tell the judge, yes, I know that there is a judgment, but I'm afraid, and I humbly submit to you that that judgment doesn't correctly state the proposition of law. Great judges listen to young people. That's the greatness of judges of yesteryears. I don't see that happening nowadays in Supreme Court, but be that as it may. So he said, tell me why my judgment is wrong. So to cut the story short, the case was argued, my first case in Supreme Court, for 20 days. Both sides.
Yes, sir.
And at the end of it, I lost. There were, on 8 counts, the young man's petition had been set aside, election had been set aside. I won on 7 counts, but lost on 1. But fortunately, Justice Bhagwati, in a separate judgment in the this is a 1974 judgment said that he was wrong. And he gave a judgment 3 months after he had given the previous judgment, accepting my proposition that the law laid down by him in this judgment was wrong. That shows the greatness of the judge. But it also shows that it takes courage to stand up and say a judgment is wrong, especially if you have just entered the profession. These are qualities that people must have. Now, having told you that story, there's another interesting feature that you must remember. That when you read a statute, don't limit your reading to the cold print of the statute. There is behind every statute a soul, an emotive element. Because behind those cold prints are human beings whose conduct is sought to be regulated. You have to understand the conduct of those human beings to be able to understand the statute. So when you read a statute, ask yourself the question, why was this law made? For whom was it made? Why was it necessary to have this law? And you will then get back to thinking about human beings. Because I told you at the beginning, law deals with human relationships. So behind every law is human conduct, the regulation of human conduct. Right? Why do you give custody of the child to the mother, especially when the child is young? Because the mother can take care of the child much better than the father.
Yes, sir.
Right? That's human conduct. That's human emotion.
Yes, sir. Yes.
And that's the law. But when kids grow up, they become adults, custody doesn't remain with the mother. Right? Why? Because as adults, they can think on their own. So I am now trying to interrelate emotive human elements with the statement of the law. Right? Corruption. Right? Corruption as a public servant. Why do we have the law of corruption? Because as a public servant, whatever you have is in trust. You hold it as trust. The money that the state has is held as trust with you. If you, in the process of functioning as a public servant, through corrupt means, siphon away that money, society must punish you. There's a human element to it. Because you get to be a public functionary because society has trust in you. Society cannot function without public functionaries. So therefore, you have a duty towards society. So the empowerment of public functionaries, along with the duty of that public functionary to discharge his obligation towards society, which is why he was put there in power. That's the human element behind the law of corruption. And I can give you example after example after example. I'll give you a very interesting legal example, which I think now needs a rethink. I'll give you two examples. Number one, you know that under the 10th schedule, the 10th schedule to the Constitution was included because of the problem of ayarams and gayarams in politics. What used to happen, and this is the story which connects you to my client from Mayhem, the story that I told you about the election matter. At that time, there was no 10th schedule. We were in the 70s. 10th schedule came up in the 80s. So when people used to win elections, they used to suddenly change their sides and go to another political party and get a ministerial position or get some booty or whatever. That was, there was no law that eliminated that. There was no law that punished it. Okay? So there again, a relationship in the course of an election which allows for you against all moral, against moral parameters, allows you to change your political affiliation, though you're one from one party, you suddenly sort of switch over to another party only for a ministerial position. Now, that's human conduct, no? So if that happens in politics all the time, there'll be so much instability in politics that, that you won't have a stable government. So Parliament decided, no, we must regulate this conduct. So behind the 10th schedule was regulating this kind of conduct, right? So we challenged the anti-defection law. I and Fali Nariman argued this matter way back, challenging the law in the 90s. And the Supreme Court, by a constitution bench, by a majority of 3-2, upheld the law. And one of the submissions that both myself and Nariman made at that point in time was that this law allows the speaker to determine the fate of members of parliament or members of the legislative assembly in the event they incur a disqualification. And under the 10th schedule, there are two possible disqualifications that you can incur. Number one, if there's a whip issued in parliament or in the assembly and you vote against the whip, then you incur a disqualification. And the second is if you voluntarily give up membership of a party, then you incur a disqualification. Recently, you know that in Madhya Pradesh, many people resigned and sort of now have joined the BJP. So these are two disqualifications set out in the 10th schedule for which your membership can be taken away. So we argued at that time that this power to determine whether a person should be disqualified or not should not be with the speaker. Because in India, unlike in the UK, the speaker continues with his affiliation to the political party of which he was a member before he became a speaker. So the result was that ever since then, whenever a disqualification petition comes before a speaker of a member of the party to which he continues to belong, that petition is never taken up by the speaker. That's what we have seen over the years. And whenever there is a disqualification petition qua a member of the opposition, the speaker will take it up immediately. This point we had raised for a long time. Then two of the judges of the Supreme Court in that constitution bench agreed with us and said, yes, this law is unconstitutional on that count. The majority, led by Justice Venkatachalaya, if I remember correctly, said, no, this law is good. But now experience has shown that we might have been right. In fact, recently, there's a judgment by Justice Nariman, very recently in respect of Manipur. What happened was that a member of the Congress party in Manipur, after the election results were declared, on that day itself, became a minister from the opposition party. And a disqualification petition was filed. Over 3 years passed, and the speaker never took up the disqualification petition. Had the disqualification petition been taken up, he would have been disqualified straight away because there were no disputed questions of fact. It was part of the record of the assembly that he became a minister after having won on a Congress ticket. But for 3.5 years, the speaker did nothing. He didn't even issue notice on the disqualification petition. And when the matter went to the High Court said, what can I do? This is the law. This matter has to be decided only by the Supreme Court. So the matter came to a bench where Justice Nariman was presiding. So the Justice Nariman asked the speaker, told the counsel for the speaker that when are you going to decide this petition? So the speaker said, well, counsel said, I'll find out from the speaker. So he came back and said that I need 2 months' time. The judge said, nothing doing, you decided within 4 weeks. And if you don't decide within 4 weeks, we'll take a position on it. The problem has been that Supreme Court has in some judgment said, or there's a matter pending in before the Constitution bench, that the court cannot issue a mandamus to the Speaker to decide a particular disqualification. Why? Because the Speaker is a high constitutional authority. So the speakers know that courts will not issue them a mandamus to decide matters. Speakers won't decide matters. And then many a time, 5 years will pass and the Speaker will not decide a disqualification petition. Now the time has come, therefore, either to hold the law unconstitutional, 10th schedule unconstitutional, or to give a mandamus to the Speaker. So Justice Nariman, even after 4 weeks, the Speaker said, I need more time. Justice Nariman said, nothing doing. The gentleman who is the minister is now, we issue a mandamus. What happened was that Justice Nariman then said he removed him from the ministership. And he, in his judgment, said it's time to re-look at the 10th schedule. He said, our experience in the past has been that speakers do not decide cases of the parties, of members of parties to which they belong. Don't take it forward. So what I had indicated, myself and Nariman had indicated years ago when the law was debated, ultimately now is coming true. Why is that? Because law is related to human conduct. When three judges upheld the law, that's the Constitution bench upheld the law, they thought that speakers would conduct themselves consistent with the dignity of the office. But human conduct has proved that assumption to be wrong. So law intervenes. That's why I'm trying to give you the connectivity between law and human conduct. So because law has intervened now, there'll be fresh thinking about this, right? The other issue, again, this is something that the law is yet to grapple with, also relates to defections. Nowadays, what happens is that people who belong to certain political parties, and all political parties are the same. I mean, I'm not here as a congressman. I'm here as a lawyer. So all political parties always try and hijack governments. Right? So what you do is you pick up 10 people, 20 people, fly them out in your own plane, right? Put them up in a resort, put them up in a hotel. Then go and tell the governor that, look, the ruling party has lost majority while you've kept them captive, right? Ask them to send their resignation letters. And the Speaker, when he tells them, look, come and appear before me, they won't appear before him. And then the governor says, yes, you have lost majority, have a floor test while those people are captive. And then you lose government. Now, this is not how the 10th schedule was supposed to work. Right? The ingenuity of human conduct or misconduct, if I may put it that way, is such that it destroys legal processes. And there's a constant battle between law and human conduct. And you will find that in the history of civilization. It is not just today. There's a constant conflict between law and human conduct. Slavery was legal. From the west coast of Africa, people used to be taken to the United States of America, made slaves, right? That human conduct of believing that human beings are your property, ultimately what at variance with the moral standard of society, which keep on changing. And so law intervened and said, no, this is wrong. Men cannot be slaves. Human beings cannot be slaves. There is a right to equality, right? And then, of course, came the Declaration of American Independence and the rights enshrined in that declaration. They became the torchbearers of freedom throughout the world. So the battle started from Magna Carta. And we have reached today at a stage where we are still battling it out. The stratification of our society within the stratified caste system is in fact the very antithesis of equality. The way our Dalits are being treated in our country. They still cannot take water from the same well. The law may say anything, but the conduct of human beings is contrary to the law. And it takes time for law to catch up. It takes time for human conduct to also change. And that's why Ambedkar said, he said, look, the fact is that unless Brahminical hegemony and the caste system is destroyed, there'll never be equality. So he said, let's have social reformation before we have political reform. Social reform must precede political reform. Now, why do I say this to you? I say this to you because these are things that you must study. And these matters will come up in court. And they all relate to human beings. The substance of law, the foundation of law is human conduct. Right? That's also true in court. Your conduct will also determine the outcome of your case. And your conduct doesn't mean just your conduct by being nice to the judge. No, your conduct in the manner in which you have prepared your case, the manner in which you present your case, the industry that has gone behind that case, the wealth of knowledge that you have that you want to put into the case. These are all very, very important issues. And you'll always succeed. You'll always succeed if you're better prepared than anybody else. And remember, when you look at the statute, and this is something that I told you earlier, when you look at the statute, never look at the cold print. Let's forget the law for a moment. Which human beings do you like more? And I can tell you that 90% of you will say those who have emotive qualities. You know, when you hear a man who talks in a very sort of cold manner, your instinct is not to like him, right? But when you're talking to somebody who has warmth, who exudes warmth, it attracts you, right? That's a human quality that attracts. So you must be warm to your colleagues. You must be warm to your colleagues. You must be warm to your clients, right? I mean, we as senior lawyers don't sort of meet clients, but solicitors. Many of you are young people. When you go out, you'll be solicitors. You'll be dealing with clients. Be warm to them. Remember, the law emerges from understanding your client, the difficulties that your client has, the troubles and tribulations that he faces, which is why he has come to you, right? Understand those troubles, understand those tribulations, understand that emotion, because it's a human issue, right? And the law will emerge from your understanding of his problem, which is a human issue. And sometimes you will realize that the particular facts of his case are such that the law needs to change. The law as settled doesn't take into account the particular position that your client is in. Either the law has not taken that into account, or you can distinguish the judgment and say, yes, that judgment applied to the facts of that case. But what the facts of my case are such that you can't apply that principle of law, right? Now, I'm now relating the emotive qualities of the factual situation that you're dealing with the cold print of the law, right? That cold print is found in judgments. Judgments are also cold print, right? But you have to get into the soul, the heart behind the law, right? And that's really fundamentally the last issue that I wanted to tell you about. But having said all that, as I said to you, there is no one quality that would make you a successful lawyer. Be a complete human being. be a human being with sensitivity, a human being who seeks to understand, and always have an open mind. That's also a very important quality of a lawyer. See, I'll give you a little sort of a story, not a story, but a little parable or whatever, which will make you understand what I'm saying. Supposing there are two of you in a helicopter, and you're flying pretty high, and something happens to the helicopter, and you have to jump down, and both of you have parachutes. So you jump down. Now, one person's parachute doesn't work. So he'll meet a very, very unfortunate end. The other person's parachute works, and he comes down slowly and lands safely. So that parachute is your mind. If you keep it open like the parachute, you'll never meet an unfortunate end. So always keep your mind open. You will land safely. Never forget that. And open mind means appreciate what your opponent says. Appreciate what your judge says. Try and understand it rather than say, it's a useless argument. It may be a useless argument, but at least try and understand it. Right? That's not just the quality of a good lawyer, it's the quality of a good human being. A good lawyer must also be a good human being. He must not, remember I told you that story about that gentleman who came to me and who lost the election, right? Now, I didn't care about the money. You're not selling products. You're not selling, a commodity in a shop. You're providing a service. And service must be provided to the needy. Many of you perhaps don't know, but sometimes, most of the time, between 30 to 40% of all that I do is free. Mostly, people who are being persecuted by the state. I help them. I don't charge. That's a cause that we must all take up. We must do pro bono work. We must help society. There are lots of people, millions of them, who don't have access to courts, who don't have access to lawyers, who cannot get the best kind of legal advice. Take up those issues as young lawyers and move forward. That's the only way to be. And, commerce is for those who buy and sell products, not for lawyers. And the last thing I wish to tell you, again, that's a very important thing. When you climb a ladder, think about it. When you climb a ladder, you have to hold on to the ladder to climb, right? That's true about life as well. When you climb up, you always need somebody's support. Maybe your senior, it may be a helping hand that one of your colleagues has given you. It may be a judge who likes you very much, likes the way you argue. You cannot rise without support. And if you give up, in other words, if you don't remember those who supported you, then you're not a good human being. So always give back to society. Give back to all those who supported you. And never forget that. That's also a quality a lawyer must have. So I think we've had it just has been a monologue. I wish we could have we could have had an interactive session. It would have been far more interesting. But be that as it may, it's been a delight to be with you, albeit it's been a monologue. but I hope that you've got some insight into how to walk out of your law school and confront the world as a lawyer. I wish you all the very best in your profession, and God bless you. Thank you very much.
Thank you. Thank you so much, sir. And very well, you said that lawyer must be social as well. That law and
Yes.
society both are interconnected. Yes, sir.
Correct.
Thank you so much, sir. And one of my student, he is Aryan Srivastav. He want to know something with your permission, sir.
Sure, sure.
Yeah. Aryan, you may ask. Can you hear me, Aryan Srivastav?
Yes, ma'am. Yes, ma'am. Hi.
Yeah.
Good morning, ma'am. Good morning, sir. So, I actually have a doubt which I actually asked to want to ask you. So, basically, you talked about how you have witnessed a generation of lawyers and you've worked with all of them. And so, my question is that when you say that you go inside the courtroom and understand the psyche of your fellow counsel and your judges. So, what has been the difference in approaches which people have taken, which like the past approach which the veteran lawyers have taken, and the approaches which the new generation lawyers are taking up inside the court? So, like, is there a pertinent difference between both those approaches? Like, people consider different things while going inside the court, or is it just the same old convince the judge, get your case done, and then leave?
No, I think that the lawyering has changed. The conduct of lawyers have changed. They've become far more aggressive. They've become far more competitive. I think that they interrupt much more. I think the kind of etiquette that was that we used to follow, we belong to the old school now, is no longer followed by young lawyers. And I think that's a loss. That's a great loss to the profession. And I think that we need to go back to a civilized manner of discourse.
So one more thing which like I just want to have a general idea about. So it's like when we go outside the law school and see the real world, like how courts work and how dealing with the clients work, and then you see that there are so many people dealing with so many apostasies. So like, is it always about the personal motive which people carry with themselves, or is it about the social work which they are supposed to do as good individuals and good lawyers? So like, because the approach has changed over time, because what we see now is more of a profit driven business rather than a social work which the lawyering was supposed to be. So
well,
how does it get better?
I indicated that in the course of my talk, that lawyers have become commerce oriented, commercial. They become commercial. They think themselves as commercial people who need to extract money from the client. I think that approach must go. It's a service. As I said, it's a service. You're not selling products. But unfortunately, the modern generation, but I don't blame the modern generation either. I'll tell you why. Because the cost of being a lawyer in my time when I was a young man was much less than the cost of being a lawyer today.
Right.
And there are many more people, so the competition is much greater. Lawyers used to, the profession of law used to be the sort of, I would say, the last option for many who were successful in life. And for those who were not, they used to take up the profession of law at that point in time. But I think now the best minds have come into the law, and most of them are going into corporations because they get a good salary. But if you are in the litigation business and you're not with a corporation, it is far more difficult because of the level of competition and because of the numbers in the profession to succeed. And therefore, that's also changed attitudes. But as I said to you, every lawyer gets an opportunity. I got it way back in 1974 and I never looked back. Every lawyer gets an opportunity. So the key is to seize that opportunity. And you'll never be able to, and you'll never look back.
Thank you so much.
Thank you, sir. Your all 6 points were really very informative. Aryan, I think that you had all the 6 points which earlier sir had quoted in the initial words. Am I right? Yeah.
Yes, ma'am.
Now I would like to invite Ms. Hemangini for vote of thanks.
A very good afternoon to everyone. We, on behalf of Manipal University, Jaipur, would like to express a deep sense of appreciation and sincere thanks of gratitude to Kapil Sibal sir for enlightening the students with knowledge and teaching us that hard work is the only way to success that pays off. In future, when people would speak about pandemic corona, I'll always remember this speech, as even during times of no college, we had gained such a bulky quantity of knowledge from you, sir. Further, we are grateful to Dr. Vijay Lakshmi ma'am, Director, School of Law, Manipal University, Jaipur, and Dr. V. N. Mathur sir for encouraging the students always to soar high in life. We would also like to acknowledge and express sincere word of thanks to Excelegal for their cooperation and providing us with the platform. Lastly, expressing a deep sense of word of thanks to Mr. Puran Rajpurohit and team for being the base of lecture and getting the lecture from the scratch to the sky, and to our dear participants.
Vijay
So much,
Lakshmi ji.
sir. Thank you so
Vijay
much,
Lakshmi
sir.
ji.
Thank
All
you.
the best. God bless the institution and
Thank
you
you,
all,
sir.
and to the children. Okay,
Thank you.
bye-bye.
Thank you, sir.
Thank you, sir.